Good afternoon, everyone. Apologies for the technical difficulties. Welcome to today's iteration of the live employment law Q&A. My name is Teilen Celentano, here with employmentlawyer.ca. I'm an associate with Samfiru, Tumarkin. I work out of our Toronto office. So, as always, if you have any questions today, whether you're watching through YouTube, LinkedIn, Facebook, X, go ahead and ask them in the comments or in the chat, and I'll do my best to answer them live. You can also go to our website at employmentlawyer.ca or email us at help@employmentlawyer.ca. Before we get into it today, I'd like to talk about two quick topics. First is the recent news that Shoppers Drug Mart was looking to bring on volunteers instead of employees. This is, unfortunately something that employers have done for ages, whether it's trying to bring on volunteers to take the place of employees, whether it's through the form of unpaid internships. Employers throughout the country have always attempted to circumvent minimum wage laws, vacation pay laws, and other laws that are meant to protect employees. So what does the law actually say? So first and foremost, unpaid internships are largely outlawed in the province of Ontario. While there are certain exceptions for people who work, who are secure these placements through university, through a co-op program, what have you, by and large, if you are doing work and the point of the work is to support the business and to further your career, you're entitled to be paid for that work. What are you entitled to? Well, you're entitled to at least your minimum wage as set out by the Employment Standards Act and the regulations thereunder. But you're also entitled to vacation pay, public holiday pay, and protections under the Occupational Health and Safety Act. If you are currently working in an unpaid internship and you are taking the place of a paid employee, well, then you have recourse to not only get paid going forward, but then also to get back pay. So if you're in that situation, it's important that you contact us. One of our lawyers can help you out, but you would be entitled to at least minimum wage for the full time you worked. You'd be entitled to be paid at least that minimum wage on all your hours going forward. You'd be entitled to vacation pay and public holiday pay as applicable. But most importantly, in a situation like that, the company would also be prevented from retaliating against you for enforcing your rights under the Employment Standards Act. The people who drafted the provincial government, when they drafted that legislation, they knew that enforcing your rights under the Employment Standards Act they anticipated that it would be frequently met with opposition from the company, and understandably so. So in drafting the Employment Standards Act, they explicitly outlawed any type of reprisal against an employee. Now, reprisals can take multiple different forms, and they're more than just terminating the employee for attempting to enforce their rights. Reprisals can take the form of reduced shifts. It can take the form of a change of duties. It can take the form of a reduction in stature in the workplace. There are many different types of reprisals, and it's not just limited to the overt type of termination that most people would anticipate. So if you are doing an unpaid internship and you do enforce your rights, you're safe to do so because your employers are prevented from retaliating against you. The second issue I'd like to talk about is the return to office mandate for federal employees, federal government employees. So recently, last week, the federal government announced they were mandating a return to work policy for all of their employees, and that employees would have to return to work in the office at least 3 days of the week. Now, while every individual employee had different circumstances of employment, by and large, most of those employees were working pre-pandemic and we're in the office 5 days a week. So one of the questions we've been frequently asked as the COVID pandemic has winded down is, are employers allowed to do that? Can an employer make me go back to the workplace? I don't want to. I like working from home. What are my rights? Well, the short answer is it depends. And when it depends on what the circumstances of your employment were when you were hired. If you were hired pre-pandemic and you were working, in the office 5 days a week, and then the office closed for the duration of the pandemic, and then at the end of it, they said, okay, everyone's coming back to the office. That was allowed, right? The change to the terms of your employment, meaning being allowed to work from home, was intended to be temporary. And as soon as they were allowed to have you return to work, they did. So in that case, yes, it's allowed. Whereas if you worked for an employer, same situation, but instead of making you come back to work after the pandemic, they allowed you to keep working from home. And now, 2 years after the whole world reopened, they're trying to make you come back into work. Well, now we have an argument that working from home full time had become a term and condition of your employment, right? Just like an employee's rate of pay can change, just like their hours can change, just like their title can change. When a change like that happens, it becomes set, right? So when that change to the term of your employment, meaning you were allowed to work from home full time, was changed, an employer can't just take that away for free. Just like an employer can't give you a raise this year and then take it away next year of their own volition. So if that, in a case like this, where maybe you worked full time for 2 years, now they're trying to make you come back, you may have a case. Again, it is a case by case analysis. We can't, there's no blanket rule when it comes to this stuff with COVID stuff, because it is so new. As much as it is 4 years old in the eyes of the law, that's still quite new. We still rely on cases that are 40, 50, hundreds of years old. So it is a moving target, but if your employer is now trying to make you go back to work after having worked from home for the past 2 years, you may very well have a case. And then the last situation on this topic is what happens if you were hired during the pandemic as a full-time remote worker, and now your employer is trying to make you go back in, trying to make you go into the office for the first time. Well, in that case, that is likely a constructive dismissal. In that case, when you were hired, it was a term and condition of your employment that you would work from home full-time. Unless there was a specific clause in the contract that said we can do this if in the future, if business needs require it, or something of that nature. Then if a company for the first time is making you go into the office where you didn't before, that is a change to the term of substantial change to the terms of your employment and is grounds for constructive dismissal. I have a question here from Nina from Facebook. I worked for an NGO for about 16 months. My original contract was for a year, but ended 6 months early due to budget cuts. I was given 2 weeks notice only. I received no severance pay. Am I entitled to it? So Nina, you're actually entitled to more than just severance pay. In your case, you're entitled to breach of contract damages. So by and large, most employees are considered indefinite term employees, meaning you're not just employed for a fixed period of time, you're employed indefinitely going forward. However, when you are employed on a fixed term contract like you were, Nina, so from January 1st of 2024 to January 1st of 2025, as an example, then that's how long you're employed for. And if you're let go in Ontario as a provincially regulated employee early, then you're entitled to be paid the balance of that contract. So in your case, Nina, you wouldn't just be entitled to severance on the basis that you were a 10-month employee. You would be entitled to the full last 6 months pay. And it's different from severance. It'd be considered breach of contract damages, but you're still entitled to all of that money. So in that case, it's important that you reach out to us. It's important that you reach out to us and speak to one of our lawyers who should be able to help you out and help you go after that money you're entitled to. Question from YouTube from Desi T. Hello, I am on modified duties. Could my employer change my job location or job role? So Desi, it depends on the nature of those modifications that you require, right? So employers in Ontario have a duty to accommodate disabilities, whether or not they originated at work. So if you get hurt at work, yes, they have to accommodate you. Or if you get hurt at home shoveling your driveway and it prevents you from doing your job, your previous job, they also have to accommodate you there. So in your case, again, I don't know what the nature of your job was and what your accommodations needs are, but assuming you can't do that previous job, then yes, they're allowed to change your role, right? If you were a general laborer, as an example, and then injured your back, to expect you to It would be unreasonable for them to expect you to continue to be a general laborer going forward. However, if you were, again, you're someone who worked at a desk and broke your foot, you wouldn't really be required to be accommodated in the workplace. So whether they're allowed to change your role or your job location really depends on the nature of your job and the nature of your need for accommodation. And unless we know everything, it's difficult to give a full opinion as to what they are and what they are not allowed to do. So in your case, I would recommend you reach out to us at employmentlawyer.ca. Okay, hopefully this works better now. Okay, so the next question is from Elaine on Facebook. Elaine asks, my company restructured and eliminated my position. I've been with the company 9 years and in total will receive 19 weeks severance. After reviewing the package, I decided to sign, but now I'm having second thoughts. I wrote them before signing, requesting that they up my severance based on my age of 59. In the current economic and retail climate, they refused to do so. Can I fight this or is it too late? So Elaine, it depends on whether or not you signed it, right? But it sounds of things you did, and second thoughts and whether or not, whether you had the opportunity to consult it is an argument that can be made. But generally speaking, once you've signed that release, once you've signed that termination paperwork, you're bound to follow it. The company is as well. So if in your case, you did sign it and they're refusing to increase it all now, you may be out of luck. But that being said, it does depend on a case by case. In a case like yours, a 9-year employee receiving only 19 weeks is significantly lower than they should be entitled to, whether that's in court or even through an early settlement. So I think in your case, Elaine, it's really important that you reach out to us at employmentlawyer.ca so one of our lawyers can help you out. But what Elaine's situation really does is it highlights the need for legal advice, right? So it's not just especially when you're let go, but not just when you're let go, is it a good time to speak to a lawyer? A lot of people think that people in human resources are their friends and that they're there to protect them, when in reality, the human resources department of any company is there to protect the company from liability and hopefully to prevent them from getting sued. So if you're ever in a situation where you're dealing with HR, it would make sense to reach out to us and speak to one of our lawyers who may be able to assist you. I've got another question from Fred. How difficult is it to prove age discrimination? So Fred, generally speaking, it is difficult, but it's not impossible. In order to prove discrimination, when we allege it, is incumbent on the person suing to prove it, right? It's not like you see in court where it's all beyond a reasonable doubt and it's, we have to completely convince a judge, but instead we have to convince the judge on a balance of probabilities that age discrimination took place. A balanced probabilities, you need 51% chance at 51% it did versus 49% it didn't. And while difficult, it's not impossible. And we, in our courts and our judges, they look at things beyond just what the paperwork says. They'll look at more constructive, more circumstantial things to, attempt to see it. But as always, with cases of discrimination, whether based on age, based on sex, or what have you, it's really important to document things. Not just, of course, documenting if you get an email that's discriminatory in nature and they're making a comment about your age, or document policies that withhold certain things from people of a certain age. That obviously make sure you keep track of. But if there are comments that are made, whether in passing, during meetings, during formal interviews, that you believe are discriminatory, it's important to keep track of those. Not just I was told this, but the date and the approximate time on which it is said. One of the things we always see in cases where we're dealing with discrimination that may have occurred 6, 8, 12, 18 months in the past is our clients will remember things that happened. They'll remember things that they were said. They remember how they were made to feel small, but they can't remember when it happened, where it happened, why it was said. So in cases like yours, it's important that you document, on this date, I was told by so-and-so this. And one easy way to do that is to start by sending yourself emails. Sending yourself emails, while it is rudimentary and it is very simple, it does a couple really good things in terms of record keeping. One, it shows it's personal, right? So you don't have to worry about someone else in your office finding it. You don't have to worry about anything like that. The second thing, you don't have to worry about your handwritten notes being lost. Unfortunately, people lose things, people spill things. Those handwritten notes that could prove consequential to winning your case could be lost. So doing everything over email prevents that. But most importantly, what sending yourself emails does is it creates a timeline, right? So today at 1:15, so-and-so told me this. And we can prove in front of a judge that you took these notes when they happened or shortly after they happened. And that's important because our courts recognize that people's memory fades, right? You'll remember something that just happened because it just happened. But if something happened 6, 8, 12, 18 months ago, you will have a more difficult time remembering it. And as such, our courts put less stock into it. But if you're able to show that, look, 18 months ago, when this was said, I wrote down verbatim what was said to me and by who and in what context. Well, now we have a much more compelling argument to make in front of the judge. So in your case, Fred, it's difficult to prove. It's not impossible. Make sure you're documenting everything. And if you think you've been discriminated against, reach out to us. Next question from Linda. When employers install security cameras in the workplace, where should they be? Can they use them to record conversations and manage staff? Does this violate any privacy rights in the workplace? Are they allowed to place hidden cameras? So, Linda, it depends on the type of job you have and whether or not there's a reasonable expectation of privacy is ultimately what it boils down to, right? So one thing that I think everyone would agree to and makes sense is you can't put cameras in the bathrooms, right? That would be unfair. That would be wrong. That would be inappropriate. But cameras in other places in the workplace can make sense depending on the workplace and the type of work you're doing. Generally speaking, if it's a general office space, then yes, they can install cameras and they can install hidden ones if they so choose, provided in that area there is no reasonable expectation of privacy, right? The employee doesn't reasonably expect that they would have a modicum of privacy in that workplace. So, for example, if you work in an own private office, it may be different than if you work in a bullpen, where there are a number of cubicles where everyone can kind of poke their head into every cubicle and see what's going on. So unfortunately, employers can generally place cameras in a workplace and they can use them how they see fit. So if they want to use it to police their workplace, meaning who's doing what and when, then they're allowed to do that. Similarly, they're allowed to have hidden cameras, but again, it needs to be in the right spaces. What the real issue becomes with the cameras in the workplace is where they're located, right? And whether the employees in that location have an expectation of privacy. Jill from YouTube asks, can a person who is placed in an acting supervisor position with a verbal promise to be made permanent after 3 months be arbitrarily removed and sent back to her former position without any competency-based reason? So Jill, this is a difficult spot. So contracts are contracts, right? In order to have a contract, you need 3 things: an offer, acceptance, and consideration. So in this case, the position was offered to you verbally, you accepted it, and the consideration was you got the position, right? So it is a binding contract, but again, it comes down to what we saw with Fred was, can it be proven, right? Can we prove that conversation actually happened where they promised to make it permanent after 3 months? So without knowing that, without knowing how the conversation took place, when it took place, whether there's any supporting documents that would support you, it's difficult to say. But ultimately, Jill, it would come down to whether or not we can prove that you were told it would be made permanent after 3 months. As I'm sure you can imagine, when someone is in an acting position temporarily, so they temporarily get promoted from a regular worker to a supervisor, the company can't just unilaterally drop them back down without a reason for it. So one of those reasons is it was only ever temporary. Potentially you were covering a medical leave, parental leave, a reservist leave, any type of leave for that 3-month period, after which that other person would return, you would be returned to your previous position. In that case, that's fine. However, if a company just chooses to just demote someone who previously held a supervisory position to a non-supervisory position, well, then in that case, that demotion and corresponding reduction in pay is likely a constructive dismissal, and that person would be entitled to a full severance package. Again, as I mentioned earlier, and as we mention every week on our show, what is a full severance package depends on a number of things. It depends on the circumstance of someone's employment. So in your case, Jill, to answer your question, it depends whether or not there's any documentation. By rule, no. If they promised you verbally, that's a binding contract and it is enforceable, but it always comes down to what we can enforce, right? And what's your recourse? In this case, your recourse would be starting a constructive dismissal claim and pursuing a severance package. While we wait on more questions, I'll circle back to the question Desi asked earlier regarding workplace accommodation. So a lot of employees find themselves in a position where they've either been hurt or they become sick, and they find themselves in need of accommodation in the workplace. And while they know that their employer has to do something, they don't know what those limits are. They don't know where, the duties of the employer in that case stop. So whenever someone needs to be accommodated, they can be accommodated on any number of protected grounds under the Ontario Human Rights Code. Those include age, disability, gender identity, gender expression, all those things. And if you need to be accommodated on the basis of disability, the employer has to do so up to the point of undue hardship. Now, not only do they have to accommodate you if they can, they also have to make the requisite efforts and ask for the right documentation in order to try and accommodate you. It's not enough for an employer to say, we don't offer accommodated positions, we can't help you, sorry. They have to request the right information from your doctor through you, ask, what are this person's accommodations? What can they do? What can't they do? Importantly, when in doing so, they're not entitled to your diagnosis, just what your ability to work is. And once they have that information, they have to look within their company and see if there are if the role you were previously in can be changed, can be modified, can be altered in any way to allow you to do the job. And if that's not possible, then they also have to look within their organization to see if there are any other positions which you could have held. For example, if you worked, if you installed Wi-Fi modems for Rogers, right? It was a physical job, and then you broke your legs and you couldn't walk anymore. Well, you probably can't do the previous job you did because not every home where you had to go install modems was accessible. But given the size of Rogers, there are other jobs which you can do. You can go work in their call center. You could go work as a sales representative at one of their stores. So the bigger the company, the harder it is for them to prove undue hardship and therefore an inability to accommodate you. That bar of undue hardship is incredibly high. It is not easily met. So whenever an employer says we can't accommodate your disability, it's always a good idea to reach out to us at employmentlawyer.ca to see if that's correct. And if it's not, and if an employer refuses to accommodate you and instead leaves you out there in the wild on an unpaid medical leave, well, then their failure to accommodate you in accordance with Ontario Human Rights Code can often be enough to pursue a constructive dismissal claim. Last question today from Kevin on Facebook. He asks, I've been working for a siding company for 10 years and haven't been called back. 2 workers are still working though. CRA told my employer I'm owed 2 days pay for every year that I worked. Is that correct? So no, it's not. I believe what the CRA told them is is your minimum entitlements under federal law. But given you worked for a siding company, it is likely that you're a provincially regulated employee and your entitlements thereunder are vastly different. So in your case, Kevin, if you've been working for the same company for 10 years, and by the sounds of things, I'm inferring that given it's a siding company, you're laid off during the winter and come back to work in the spring, then you're entitled, if they're not returning you now, and it's been longer than 13 weeks, again, assuming you're in Ontario, then you're entitled to a full severance package. So not only are you entitled to, you're entitled to that full severance package based on 10 years of service. So you could be entitled to as much as 24 months, again, depending on availability of similar employment and your age, and again, your 10 years of service. But more so than that, you're entitled to your ESA minimums. What your ESA minimums are, they're the bare minimum entitlements you're entitled to under the law. They're not subject to any duty to mitigate, and they're non-discretionary. So generally speaking, someone who works somewhere for 10 years is entitled to a bare minimum of 8 weeks termination pay. And then they're entitled to additional week of severance pay if that employee has been, per year of service, if that employee has been there for longer than 5 years and the company has a payroll of over $2.5 million. Now, while $2.5 million is obviously a lot of money, it is actually a bar that is met more frequently than most people realize. If you have 50 employees making $50,000 a year, you have a company payroll of $2.5 million. So in your case, Kevin, if you haven't been called back for the first time in 10 years and other people are already working, it's really important that you reach out to us and speak with one of our lawyers who'll be able to help guide you through a constructive dismissal claim. Thank you today for joining us, and my apologies for the technical difficulties. Please join us next Wednesday, May 29th at 1 p.m. with Lior for our next one. Again, my name is Teilen Celentano, and this has been the Live Employment Law Q&A. Thank you.